Please be seated.
Thank you, Your Honor. We're back on the record matter of state of Washington versus Rural County, Second Public Version, 01670, and we're now before the court sentencing before I launch the state's recommendation three. I want to ensure that the court has seen and had opportunity to review the material submitted by both parties before today. I think by my recollection, that should include victim impact statements submitted by friends and family of victims, a defense sentencing memorandum that was submitted this morning. I think that's it.
Okay, that's what I have, a victim impact statement from Mr. John Holmberg and Ms. May Robson, and I do have the defense sentencing memorandum, and I have reviewed all of those.
I do want to let the court know now that there are at least a couple people who would like to take the opportunity this morning to address the court, people who did not submit statements in writing. Let me know who they are when we get to that point.
Okay.
We'll see momentarily. But by way of brief comments and the state's sentencing recommendation, I'll say this. Jay Cook and Tammy Van Cuylenberg were killed in November of 1987. The court knows that more than 30 years went by in the interim, during which time families were left with questions unanswered. Their grief transitioned into frustration and ultimately into kind of a sad acceptance of the possibility that their questions would never be answered with some glimmer of hope underneath. During that same period of time, the defendant lived his life. He ate, he slept in his own bed, he made friends, he traveled, he worked, all as a free man. And finally, the time has come for him to answer for the horrendous crimes that he committed back in 1987. The evidence in this case established beyond a reasonable doubt that the defendant committed the most serious crimes under the law of the state, and the appropriate penalty for those crimes is the most serious sanction available under the law. This is mandated by statute. The court doesn't have any discretion in this regard, but I would submit that it's not just automatic. It does have meaning that the sentence of 2 consecutive terms of life in prison is just and appropriate given the defendant's actions in this case. So that is the state's recommendation. I will leave the rest of the details up to the court. There are some minor claims for legal and financial obligations. I don't know about a claim for restitution, but that might be forthcoming. There's no point in discussing community custody, so I'm not even going to go into that. But I'd be happy to answer any questions the court has about the logistics of the sentence.
I don't think I have any other questions at this time, so if there are family members who wish to address their friends, who wish to address the court, I'll hear from them. I will also hear if there's anyone here on behalf of Mr. Talbot.
Thank you.
That's appropriate. If you could come up forward here, and if you would state your name, ma'am, and spell your name for the record, okay?
My name's Liladastra, L-I-B-R-A-B-A-A-N-S-T-R-A.
And you can proceed. And if you have something you want to read, that's fine, you can read.
Victim impact statement. What does it even mean? I've been impacted by so much and so many people. 32 years ago, I naively thought Jay and Tanya were the only 2 victims. Now I see so many victims. By Talbot not pleading guilty, put a whole new generation of people through his war. Do I mention the impact defense attorney Rachel Ford has had? She callously went.
Objection, Your Honor. Not appropriate. No, it's not appropriate to personally attack the attorney.
I would agree.
Or should I focus on thanking all of the people involved? The jury, 15 men and women who had to witness this trial, how ugly this has been for them. The witnesses that came forward and gave their time, their commitment to see that justice was served. I thank you. Or my family, Mom, Dad, and Kelly, who have been by my side, living through and helping me through these dark, sad months we have endured. I thank you. To my kids, my friends, John, Van, and May, for being so supportive, kind, and loving. And then how do I thank all of the people of this law and order community that have given 100% of their jobs? Jim, Justin, Matt, and Nancy. The people who have taken on the responsibility of catching and prosecuting Talbot. They have given so much of their time, heart, and passion to see this through. How can I stand up here and talk about being a victim when I have so much love coming in from all sides? Number one by a million miles is my husband, Gary. I thank you. You held my hand 32 years ago. You got me out of bed, got me to brush my teeth and my hair and face the world. And you did it again 32 years later, helping me stay centered, to get me up and make the best of each day. My love, I thank you. Or do I talk about Jay? This great big hole, this never-ending heartache. Or do I talk about Jay, this great joy, this close confidant, this best friend? I shared my life with Jay for 18 years. The love he gave to me, the acceptance, the feeling that I truly belong. Because if you're lucky, that's what family does. No words sum it up better than thank God. Talbot is finally off the street. We, along with the people of Skagit and Snohomish County, can all breathe a sigh of relief. Thank you, Your Honor.
Thank you, ma'am. Mr. Bullock, is there anyone else that wishes to speak?
I know of at least one other, yes.
Ma'am, if you would state and spell your name.
Leona Cook, Leona Cook.
You can proceed.
Hello. My name is Leona Cook. My husband Gordy is here. My daughter Kelly. And my daughter Laura with her husband Gary. Jay was our second born. He was between his two sisters. Kelly was 22. Laura was 18. And Jay was 20 when we lost her. Jay was sent on an errand to Seattle to pick up a furnace. He would have to stay overnight, so he was given a money order for the furnace, money for ferries and gas and accommodations. But the young couple decided they would sleep overnight in the truck. Buy the furnace in the morning and come home. Simple errand. They didn't come home. They had left Victoria on the 18th of November, 1987, went to Port Angeles and drove down the Olympic Peninsula to Bremerton. Took the ferry across to Seattle. Somewhere along that way, William Talbot 10 o'clock at night. It was cold, rainy on that November night. Jay would have picked anyone up on a night like that. When William Talbot got into the van, they had no idea that he had rubber gloves, zip ties, and 38 caliber handgun. He murdered Jay near High Bridge in Monroe County. He beat his head with the rock and strangled him. Then he drove north 70 miles and took the Alger exit into a very rural area. Was very rural in 87. He raped Tanya and shot her in the back of the head and left her to roll down the embankment, where she came to rest against an old rusty culvert pipe. She was found a few days later by a person walking by. He then drove north to Bellingham and left some of her belongings under the back porch of Essie's Tavern and left the van near a Greyhound bus stop and disappeared. That was in November. In December, on the 16th, it was Jay's birthday. Would have been his birthday, but he wasn't there. He would have been 21. I had a birthday present for him. And it was nearly Christmas. I had a Christmas present ready for him. When I finally went to his room to deal with his things, some of us wanted a shirt or a sweater. You could wear them. You could put them to your nose and smell him. I still have that old sweater in my dresser drawer. And I still, for 4 years, I still heard him running up the back steps to the kitchen door.
Thank you. All right, anything else on behalf of the state, Mr. Baldwin? Ma'am, if you could state your name and spell it for the record.
I'm Kelly Cook, Kellycook.
Okay, you can proceed.
Jay's older sister. I think my sister and I did a very good job. I think the ex-wives are very well. So upset. But one of the things that really I found very striking was in the opening statements, the defense stated the defendant had led an unremarkable life. And I can tell you that those kids were not good. They were cherished kids. They came from families that loved and supported them. Kids who essentially had everything to live for. The world was a kid. I believe the defendant in this case had very little going for him. It seems to me that the only remarkable thing he ever did was not to give to the world, but to take. And what he took was the lives of two very loved, very young people. Thank you so much.
Thank you. And again, if you'd state your name and spell it for the record.
My name is Doran Schiller, DORAN SCHILLER.
Okay, and you may go ahead, sir.
a sense of humor. First time I met Jay, come up the back stairs, back door, their house. Well, I was having some friends over. And I walk in the back door, back kitchen door there. And Jay and another friend, Chris, were making French fries. And I walked in and I said, "You guys allowed to make French fries?" And Jay just looked at me and said, "Oh yeah, oh yeah." And I stood there and he just laughed at me. And then I went looking for Laura. I had to tell Laura, like, there's some guys in your kitchen making French fries. So I did. And Laura came up and he just turned and looked at me and gave me the look like, "Ah, I gotcha." Jay's the type of guy who'll give you his shirt off his back, give you his last beer, give you his last smoke. Jay's the type of guy that someone was broke down on the side of the road and stop. We'd be on our way to a house party or what have you. And it would always happen. We'd be driving along, pull over. Like, "What are you doing?" "We gotta help these people, man. It's what good people do." That was another thing we used to say all the time. "You're good people, man. Don't you go change it." Jay was a gentleman. That's why Tanya took to Jay. He was a gentleman. He treated women with respect. He treated everybody with respect. Tanya was a sweetie. We used to call each other sweeties. We'd just do little kind things. And we'd always say, "Oh, you're such a sweetie." Yeah. Just want to give you an idea what Tanya was a sweetheart. Man, oh man. You know, it was nice to get to know her the time I did spend with her. And with Jay, of course, too. That's it.
Thank you.
And Jay gave me his vest 33 years ago. I didn't need it. I didn't need a shirt off his back, but it was too small for him.
Thank you. Mr. Scott?
Your Honor, Mr. Talbot seated before the court with a judgment of conviction against him. He has not had this experience before. He's lived his life without criminal conviction, without running afoul of the law, without running afoul of anything. His life is one that is not marked by a reputation for violence. He is not known to be a mean or cruel person. We've heard the witnesses in this trial. He wasn't a person who owned guns, was around guns. He's a blue-collar guy. He's a simple blue-collar guy. He's lived his life just working hard. He has close friends. Some of them are here today in court. He has family members. You saw many letters when we asked for his release or a reduction in his bail, and those people all supported him. The court has but one sentence that can be imposed statutorily, and so nothing that I say here will affect that. But Mr. Talbot has been an honorable man in my experience. He's been upstanding. He's been helpful to us, respectful. I have not seen a hint of the cruelty necessary to commit these crimes. Mr. Talbot, my experience.
Thank you, Mr. Scott. And was there anyone here that wished to address the court on Mr. Talbot's behalf?
No, Your Honor.
And Mr. Talbot, you have the right to make a statement to the court. Did you wish to exercise that right?
Stand before you, a man committed a crime that I did not commit. The level of violence in this is something that I can't even comprehend. I've got all my life as a very passive person. Never raised my hand towards anybody. Very, very rarely even get angry by anything. In my life, I've never owned, possessed, or even fired a handgun. I'll repeat that last part. I have never fired a handgun in my life. The state says that all the answers here have been answered. It's far from it. One perfect example is something you did not allow the jury to hear in early 1990s. Somebody came forward with a tape that apparently had a great deal of information about Jay Cook's death. did not allow the jury to hear it. We did not hear who it was that came forward. That's an unanswered question. That's, and why it wasn't investigated then, or why it wasn't investigated now. That's your fault. I'm sorry, but this is just beyond my comprehension to be found myself being charged with something of this nature. I do have sympathy for the family, but I also have a loathing for anyone who would think that I could commit such an act of violence. My background was investigated. Friends were brought up that I don't even remember, and they all have said the same thing. I am not violent. Even if the rare times I even drink, I've been known to be completely passive. It's just unheard of for anyone to ever think that I could commit such a violent, heinous crime. Again, I'm someone convicted of a crime that I did not commit.
Thank you, sir. Anything further on behalf of either Mr. Talbot or the state?
A point of technical clarification, it did not address the fact that the jury also found the existence of the firearm enhancement. That was part of the verdict. However, in my research about the law in 1987, it appears to me that there was not an available firearm enhancement for the crime of murder. It's somewhat ironic. There's a list of other violent Class A felonies to which it did apply, but it does not appear it was applicable. So that's why you didn't hear it as part of my recommendation.
So you're not recommending that we impose any sentence for that, but do we need to do something else with regard to that finding?
I think it's a finding that exists in the record without any practical implications.
Mr. Scott, you have any? Again, I think you could look into that after today if you think there's something else we need to do, but I will not impose any sanction for that. As it's been referred to by both the state and the defense, the court does not really have any discretion here. The sentences are a foregone conclusion, and I think pretty much people have said everything that really needs to be said. Obviously, what happened to these two young people is a tragedy. They went on a trip, what sounds like it was something of an adventure for them, and they never returned. And obviously that has impacts that are far-reaching for everybody. And I think it's clear that there are questions that have not been answered and perhaps will never be answered. The jury has found Mr. Talbot guilty of both counts of first-degree murder with aggravating factors. The court's only possible sentence on each count is to impose a sentence of life without possibility of release on count 1, which applies to the murder of Ms. Van Kulenberg, and on count 2, the court also imposes the same sentence for the murder of Mr. J. Cook. Those will run consecutive to each other. Mr. Talbot is entitled to, obviously, what difference it makes, credit for all the time that's been served, but since it's a natural life sentence, it doesn't really make much difference. In regard to the legal financial obligations, while I understand that Mr. Talbot was employed at the outset before all of this, before he was arrested, he has not been employed since. He does have some assets, but he's not going to have any further opportunity to be employed. So I'm going to waive everything other than the $500 victim penalty assessment and the $100 DNA collection fee, which are mandatory. Restitution, there are 6 months in which to determine that, so I will reserve it. Mr. Talbot can waive his presence for that, or he can request to be present. That's his choice, or he can appear by telephone. And with regard to time to pay, there's really, if he serves the sentence imposed, there is no time that he would be released. So I'm going to impose the obligation, but I'm not really going to impose a payment schedule. And the other thing I have to advise Mr. Talbot is he no longer has the right to possess, carry on, or control a firearm, and he has lost his right to vote until that's reinstated as provided by law. I think that there's nothing else that needs to be addressed in terms of the sentence, is there?
No, Your Honor.
Scott, I do need to advise Mr. Talbot, and I'm sure his attorneys have discussed it with him, that he has the right to appeal the judgment and sentence. He needs to file that notice of appeal within 30 days. If you cannot afford the costs of an appeal, you can apply to have them paid at public expense. Mr. Scott and Ms. Ford can assist you with getting the notice of appeal and the motion and proposed order to the court and getting them filed. If you do not file that within 30 days, then you would be limited to what we call a collateral attack. In most cases, that has to be done within 1 year, with some limited exceptions. And it is not, there are the issues that you can raise on such an attack are more limited. So I'm sure that I expect that they've already discussed this with you, and you will be filing a notice of appeal. And I also need to tell you that if you apply to have the expenses borne a public expense and that's approved, you can have the cost of a transcript, the cost of an attorney or attorneys on appeal, and the cost of preparation of all necessary court documents for an appeal. Is there anything else at this time?
I plan to waive the presence assignment.
Thank you. Mr. Bolduc, anything else? Thank you. Then we will be in recess.
All right.
I mean, this part of it is over, but it's never really gonna be, it's never really gonna be finished with us. I mean, it's a lifetime loss for both families.
Hello, we'll just stand a little more right there so that we're not back.
We're gonna do a three person version.
He's the talker.
Just a little closer to us.
Okay, all right,
Sorry about that.
okay.
Okay, well, what's your reaction? You were expecting this verdict, but probably weren't expecting him to speak.
No, wasn't expecting that for sure, but nonetheless, very happy to, have today over with and have the conclusion that we expected to have happen, but and you never know when things proceed in court, and so yeah, relieved to have it, have the process done today and have the sentencing done as we had expected today, definitely.
What did you think about what he said about being innocent?
Seems to me a self-serving plea. I can't imagine what else it is, unless he's going to be, unless he's got the courage to stand up and tell his story, then I can't believe his innocence plea. So, ball's in his court. Tell us what happened, and he ain't doing that.
Are you concerned about the appeal? They seem pretty insistent that's gonna happen.
No, I'm not concerned about it, but I mean, I think we all come to expect that there will be an appeal. I mean, there usually are in these types of cases. These guys are sitting around with a lot of time on their hands and not a lot else to do. So yeah, sure there'll be an appeal, but I'm not very worried about it, no.
Are you gonna keep putting yourself through all of that when the appeal happens?
Hey, that's probably, but I'm not sure. Haven't really made that call yet. We wanted to get to this stage, which was, getting the trial and the sentencing over, and today's the final step on that. So it feels great to turn a corner and finally get through to this place after 32 years almost. So yeah. Today's about getting through this process. The appeal stuff is another day, and I guess we'll address that if and when it comes.
Yeah, you sort of make the choices as you go along. Like when we got the verdict of guilty, for me, I thought that's it. I'm done. I'm never coming back. And then was quickly asked if we could do a victim statement. Is that what it's called? Victim impact statement. And through people at the court, more than one suggested that it would be really helpful and cathartic. And so that's why I put the effort into doing it. And I feel like it's over now. I didn't feel like it was over then, but I do feel a sense of it being over today.
You all seem a little bit different than you did the day the verdict was read.
Yes.
Yeah, well, that day had a lot more anxiety to it. You're on a bit of a knife edge when the verdict's happening. I mean,
Yes.
today didn't have that level of anxiety, but, you know, it was still you know, obviously it's emotional because it's our close family member, so it's still a tough day, but it didn't have that same anxiety that, the verdict day did, no.
Not even with the motions this morning for,
No, not really. You know, fortunately, the prosecution was good enough to talk to us before today, so we had, you know, their perspective on things. But you know, I was surprised by that. You know, in Canada, you wouldn't have this happen. You know, you'd have to raise those things on appeal. You wouldn't have this kind of motion at this stage of proceedings. So it was a surprise, but you know, there didn't seem to be a lot of substance there, and it was just an opportunity for them to rehash. But in Canada, either, you know, we wouldn't have the ability for the media to be talking to the jury. So you know, all of it was a bit of uncharted territory for us from Canada.
Great. Thank you guys so much for stopping and talking to us and being so open throughout the whole trial, willing to talk to us. We appreciate it.
You're welcome.
Okay, you're welcome.
thank you.
Now go home.